Hey guys, it's Anthony Bandiero here, attorney, senior legal instructor at Blue to Gold Law Enforcement Training. Bringing the Roadside Chat. Uh, this officer, I believe, is out of Missouri. Now, the officer wants clarification on what does it mean under Lange versus California that we can still enter if we believe the suspect may escape. So just kind of some backstory. Lange versus California is the recent U.S. Supreme Court case that tells us that police cannot automatically enter a home to take a misdemeanor suspect into custody. There needs to be some other form of emergency, some kind of police emergency. Now, we also know, though, that if police are chasing the person for any felony, that gets them into the home under hot pursuit under a case called Santana. But if it's not a felony, if it's a gross misdemeanor, whatever you want to call it in your state, but if it's a misdemeanor, infraction, obstruction, and so forth, you're going to have something else. So it's hot pursuit plus. Hot pursuit plus any emergency. Now, those emergencies come in various forms: imminent destruction of evidence. The person may escape before you get the warrant and come back. It could be there could be somebody harmed. You think they ran to not their own home, but some random person's house. Of course, that's going to be exigency. But you're going to have something else. Now, the court did say, or at least implied, that in many circumstances, police will have that emergency, and I think that's correct. I mean, in Lange, the cop did not articulate necessarily that he thought that Lange was intoxicated. I think that if we had evidence that the person was intoxicated, the weaving in the lane and so forth, that we may be able to justify it under imminent destruction of evidence, and the person could drink more alcohol and taint the whole case, while they're in the house waiting for the warrant, and so forth. But that's kind of what we're looking for. Now, the officer is saying, okay, give me some clarification on this imminent escape, right? The suspect may escape. What does the court mean by that? Well, they didn't tell us, did they? They didn't give us any factors. Actually, I don't read a lot of cases involving that issue about cops entering a home to take a person into custody because they may escape. We do have one Supreme Court case on the issue called Minnesota versus Olsen, where the accomplices were already in custody. It was a few days. The crime, armed robbery occurred a few days earlier. The cops showed up at the house with 8 people. They surround the house and they forced entry. And the U.S. Supreme Court, there was no evidence. There was no evidence of harm, no evidence that it can be destroyed. And the U.S. Supreme Court said, look, that's not reasonable, right? If you got that many people, you got 8 people on scene, one of them can go, and go get the warrant. This officer talks about how he's from a small department. I mean, if I chase somebody and I can't stick around, and I can't cover all 4 corners, and I don't have anybody to back me up, what am I supposed to do, right? Well, you're going to have to make that call. But I will tell you that I think the courts are going to back your play here. If you are chasing somebody for a misdemeanor and they go into their home and you don't have anybody to watch the house in a reasonable amount of time before you get the warrant, I believe that continuing the chase is going to be reasonable. I think if you chase them into an apartment and it's on the 3rd floor, you're probably done. I mean, they're probably not going to jump off the 3rd floor balcony to escape. Maybe they would, but I think you're going to hear them. You're going to see them. They're going to probably need your help after they do that. But if you have a regular home and they run to the 1st story, you have to make that decision whether or not you can reasonably protect the premises before you get a warrant. I think in many circumstances, you'll have the exigency, but the courts want you to articulate it. I think one of the big takeaways from Lange too is that the lower courts held, right before the Supreme Court overturned it, they held that, hey, hot pursuit is an automatic, no matter what the crime is. And courts, especially the Supreme Courts, don't like that, especially when you're dealing with the home. Just articulate something that's reasonable, and I think you're going to be okay. But the key is something, not just, as a matter, I can do it as a matter of routine, right? That's all I got for you. Again, there's not a lot of case on this area, but articulate it, and I think you're going to be okay. All right, guys, before you leave, hit thumbs up, comment, subscribe, share with your friends, and see you guys soon. Thank you.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.